Thank you, the Deputy Secretary General of the Hague Conference on Private International Law, for inviting me to the inaugural HCCH CODIFI. I'm happy to participate to this session entitled Trends in Jurisprudence Interpreting the HCCH Trust Convention for CODIFI, HCCH Commercial, Digital, and Financial Law Cross Borders. A quick word to introduce myself before discussing about the consequences of the non-trust system in France. I am a French notary, head of the International Private Clients at Cheuvreux in Paris, the largest notary law firm in France. My daily work is to assist international private clients with their real estate transactions in France and also to deal with international estate planning. I am therefore a professional of a single country, but I'm also familiar with the common law system. I have the chance to hold a double expertise in French and American law since I also graduated from a LLM at Indiana University, Robert McKinney School of Law in the United States, where, as you probably know, the institution of trust is commonly used. As a specialist of international estate planning, I am of course concerned by the use of the tool of trust. The origin of trust comes from the Crusades period, where before going on crusades, the Lord went to see another one and entrusted him with his patrimony. This third party was responsible for managing the patrimony in accordance with the wishes of the settlor, and the property was protected from possible confiscation inflicted in the event of conviction for a felony or a treason. You trust the person to manage your estate on your behalf. Today, the institution is mainly known in common law countries, the United Kingdom, the United States, Australia, for some example. However, some civil law countries also know the institution, such as Mexico, Quebec, Monaco, and also Switzerland, which has signed a recent law introducing the institution of trust. Unlike France, Switzerland ratified the Hague Convention in 2007. And here is the point. French law doesn't know the mechanism of trust. To be clear enough, there is no trust in France, and a trust cannot be set up under French law. France signed the 1985 Hague Convention on the law applicable to trust and on their recognition on November 26, 1991, but France has never ratified the international text. The non-ratification of the Hague Convention may be excused first by the fear of the foreign institution by the French government for tax reasons, and second, by the simple fact that there is no legal equivalent under French law. French law doesn't know the English distinction between common law and equity. This notion collides with the conception of the unity of property under French law. Only one single person can be the owner of a property. However, this concept of the unity of the property has evolved during the last years with the concept of matrimonial regime of community and the introduction of unipersonal company in 1985. These two tools show that one person can hold two different patrimonies. Spouses married under the matrimonial regime of community hold personal property and part of the common assets. A single person can hold his personal assets and be the sole holder of a company, but the two types of property will remain separate. As a consequence, the unity of the patrimony is no more an argument to the non-ratification of the Hague Convention on Trusts. Fear of the institution. I'm used to say to foreign clients that France is the land of taxation. The other major barrier to the ratification of the Hague Convention is probably due to the fear of the French system has towards this notion. In particular, offshore trusts, which are often considered as havens for fraud and international crime. Even if France and French law doesn't know the system of trust, France cannot ignore the institution legally created in a foreign country. Indeed, foreign trusts may be executed in France and may lead to different consequences. For these reasons, scholars and judges have tried to find equivalent under French law. For example, in some situations, a trust will be assimilated to legacy as soon as there is a distribution to a determined beneficiary. In other situations, a trust will become assimilated to a division of the property between the usufruct and the bare ownership. The trustee can be assimilated to the usufruct holder, the one who used and managed the property, and the beneficiary can be assimilated to the bare owner, who is the owner of the property without the use of it. Unfortunately, in other situations, there will be no equivalent at all. The meaning of a foreign trust in practice is not an easy task for practitioners. First, because the institution is unknown under French law, and second, because practitioners, they have to find a French mechanism closer to the institution of trust on a case-by-case analysis. Honestly, this is complicated when you do not know the system, taking into account that there are different types of trust in the world. This induces a hand-by-hand relation with foreign lawyers, foreign practitioners who have to explain to French lawyers the trust in details. Practitioners, such as notaries, they are used to meet foreign trust at two main different stages. The first stage is when foreign clients wish to buy a property in France through a trust, as they were used to do so in their home country. Again, French law doesn't know the system of trust, and a trust doesn't have a legal capacity under French law. A trust is not an individual. A trust is not a company, but only individuals or companies, that is to say, persons with legal capacity, are allowed to buy a property in France. As a consequence, a foreign trust by itself cannot own a real property in France. Setting up a French civil company is probably one solution for the trustee, and the French company might become part of the trust. The practitioners, they may also meet foreign trust in succession cases. In matter of succession, France is bound by the EU regulation on succession of 4th July 2012, which is effective since August 2015. The European text puts an end to the conflict of laws in matter of succession in Europe and states that a unique law is now applicable to a succession. The European text states that, as a principle, the professio juris, which means that a testator can choose his or her national law be applicable to his or her future succession. Unless the chosen law is incompatible with the public policy of a member state concerned, in some situations, a foreign law applies in France from the devolution to a succession, the determination of the heirs or legatees, to the sharing out of the estate. The applicable law to a succession may also be the habitual residence of the deceased at the time of his death, when no choice of law has been made by him before. The habitual residence may be situated in a third state, that is to say, out of the EU, and in that situation, regard should be given to the conflict of laws of that first state. The EU regulation on succession does not apply to trust. There is a general exclusion. However, a trust may be encountered into a succession file where foreign law is applicable to the succession, or either French law is applicable. And in both cases, the existence of a trust may cause, of course, legal issues. Let's take first the example when foreign law is applicable. The EU regulation on succession states in its preamble that where a trust is created under a will or under statute in connection with interstate succession, the law applicable to the succession under this regulation shall apply with respect to the devolution of the assets and the determination of the beneficiaries. In other words, a trust may be involved into the succession when a foreign law is applicable to the succession and includes a valid foreign trust. In that situation, the applicable law to the succession will give force to the trust as regards to the power of the trustee and also the designation of the beneficiary. However, some difficulties may arise by interaction with French law, even if French law is not applicable to the succession. This will be the case as regards to the land registry and also public policy issues. The French land registry doesn't know the tool of trust as well. That makes sense, since there is no trust in France. Consequently, a trust cannot be titled for the French land registry purpose. Article 31st of the EU regulations on succession provides that where a person invokes a right in rem to which he is entitled under the law applicable to the succession and the law of the member state is in which the right is invoked does not know the right in rem in question, that right shall, if necessary and to the extent possible, be adapted to the closest equivalent right in rem under the law of that state, taking into account the aims and the interests pursued by the specific right in rem and the effects attached to it. Article 31st of the EU regulation on succession fits totally with the lines of the French case laws, adaptation and finding an equivalent. When a foreign law is applicable to the succession, a foreign valid trust can be in contradiction with French law or French public policy as well. Indeed, French law has introduced last November 1st, so about a year ago, a specific provision reinforcing respect of the principles of the French Republic by introducing a prélèvement compensatoire mechanism which aims to ensure the efficiency of French forced heirship. When a deceased person has made several gifts and when a foreign law applicable to a succession in France provides no reserve mechanism protecting children, then any of the deceased children or heirs or beneficiaries, they are entitled to claim a prélèvement compensatoire on existing estates located in France on the day of death. However, the implementation of such rights requires that the deceased was, or at least one of the children, was at the moment of the death a national of a member state of the European Union or resides there habitually. If the new mechanism is in action, this means that the effectivity of the foreign trust may be totally corrupted. Issues also arise when French law is applicable to the succession. As you probably know, France is one of these countries that apply a direct and immediate transfer at death to the heirs or legatees. Unlike common law system, there is no court system to transfer the assets of the deceased. Moreover, France strongly knows the mechanism of forced heirship, which is ruled as a public policy by French courts. French forced heirship only applies to descendants in France and to the surviving spouses when he or she is not in competition with the descendants. Parents, they are no more privileged heirs. In some situations, the implication of a trust may be in total contradiction with the principle of French law. First, because of the season of the years due to direct and immediate transfer, which is in contradiction to a probate system. And second, because beneficiaries of a trust may be other persons that privilege heirs. This will be the case when the trustee and the beneficiary is the surviving spouse. In that situation, the valid foreign trust cannot be fully executed in France, and children there will be entitled to claim a share into the estate according to the forced heirship rules. Under French law, civil aspects of trust are not the only matter. The taxation part is probably much more affected and complicated. As said before, the French government feels fear as regards to the institution of trust. I will use some words of the Minister of Justice in 2007 regarding the ratification of the Hague Convention on Trust. And his words tends to lead to an unqualified recognition in France of trust governed by foreign law, which will not be subject to the same rules for the fights against fraud, tax evasion, and money laundering than those imposed on the trust under French law. Consequently, French government has implemented tax rules to valid foreign trusts executed in France. Here is the point. There is no definition of trust under French civil law. However, the French tax code knows one definition since 2011. According to the tax code, the trust is all legal relations created under the law of a state other than France by a person who has the quality of settlor by act inter vivos or mortis causa with a view to investing property or rights under the control of a trustee in the interest of one or more beneficiaries for the achievement of a specific objective. You will note that the definition used by the French tax code is exactly the same as the Hague Convention on Trust. Consequently, the definition does not allow to create a trust under French law, but the definition allows to qualify foreign structures of trust for French tax law purpose. In other words, it allows the state of France to tax foreign trust in France. Alongside its introduction into the tax code, new obligations have been created. An annual declaration of foreign trust which owns French assets, and a specific declaration when a foreign trust with French implication has been modified. The trustee is responsible for all these tax declarations. According to different requirements, trust is subject to French income tax and French wealth tax as well. If wealth tax has not been declared and or the trustee forgot to provide the annual declaration, then an additional tax may apply to the trust with a 1.5% tax rate applied to the assets included into the trust. Gift tax and inheritance tax also apply to trust when a trust is involved. French gift tax and inheritance tax apply an individual taxation based on the linkage between the donator and the donee, or the deceased and the beneficiary. Therefore, in some situations, when the beneficiaries are determined as well as their shares, then the gift or inheritance tax will use the habitual tax rate. Which, for example, may vary from 5 to 45% when the transfer is made between parents and children. However, when the beneficiary and or the share is not quite determined, or if there is no transfer at all, and the assets remain into the trust, then the taxation would be 60% of the total estate, which is a lot. So as you all understand, interaction between trust and French law is absolutely complicated, both in terms of civil law and tax law. The 2019 Congress of the French notaries, whose subject was the practice of international private law, called for the ratification of the Hague Convention on Trust by the state of France. It would ensure for sure legal effects to valid foreign trust in France and would offer solutions to practical issues. France is also currently working on the creation of an international private code. You may have a smile now, but even if France is the land of a code, of the civil code, our system does not provide a code in matter of international law. The text, which is at the moment only a draft, provides some provisions related to trust. For instance, provision number 108 gives a natural definition of trust. A trust exists when a person, the trustee, holds property for the benefit of one or more of the beneficiary for a specific purpose. These assets constitute a distinct mass and are not part of the property of the trustee. The following provisions are relating to the applicable law to trust and the choice of law in this matter. The new code will not create a trust in France. However, it will definitely give more solutions to the execution of valid foreign trust in France. As a conclusion, I would add that the ratification of the Hague Convention on Trust and the French International Private Code are totally both welcome in France. Let's do it. Thank you for listening to me, and feel free to contact me if you have any questions. Thank you.